Welcome to the fifth episode of Contracts. All right. Now we're going to move through the interpretation of contracts. I'm going to move fairly quickly, so just have your hearing ears on. First, we've gone through and we've discussed what a contract is, the nature of them, right? What forms them. We've discussed what different types, what categories they may fall into. Now we're going to talk about how they're interpreted, or the interpretation of contracts. First, 10-5, plain language laws. This is a reference to the fact that many states and federal agencies, as well as the federal government, have for formal contracts required certain specific requirements that language be less legalese. And there are fewer examples of that now because contract language can still be fairly confusing. But generally speaking, certain forms, certain documents have to be in accessible, readable format, right? The use of plain language in contracts is also important because of this notion of ambiguity, right? It's not that legalese can't be very specific, right? But its use, if it is interpreted as misleading, can be interpreted against the party that drafts that agreement. But again, that's plain language laws. Then we get to the plain meaning rule, which is only implicated when the the deviations from it are only implicated when there is ambiguity. A court is going to look at the plain meaning of a word in order to determine what the parties mean. Why would what a word means be relevant to a contract? That is a question that we should ask ourselves with regard to why are words important specifically in the study of law, right? And I know that for beginning students, it's a challenge to kind of get across the importance of not just understanding the word's denotation, which is its dictionary definition, right? But also, its connotation and context, right? Because both of those meanings may be regarded as plain meaning in regard to contract interpretation. And if your contract is being interpreted, generally it's because there's a dispute there, right? What contract needs to be interpreted? Do you have to interpret your phone contract, for example, for your wireless service? Probably not, unless you have a dispute, right? So solid plain language, right, helps because when plain meaning comes around, a court is going to enforce the agreement according to its obvious terms, right? They're on the face of the instrument. They're the black letter law of the contract, right? So this is sometimes referred to as the plain meaning rule. And words are given their ordinary meanings unless the parties decide to change the context of a certain word, right? And we generally do this by putting parentheses around them with quotes and saying that this concept means, quote, this, whatever that thing happens to be. And we do this in order to avoid what's known as ambiguity. Ambiguity is the state of words or phrases being susceptible to more than one interpretation. All right. So what if if language of a contract is not clear and unequivocal, right? If the language is clear and unequivocal, the plain meaning rule will be applied, and the situation, if it's covered by that language, will be resolved, right? But if a contract is regarded as unclear, the court has another responsibility in order to determine what is supposed to happen. They have to dig a little bit deeper and they have to ask themselves a couple of questions. And this generally arises for several reasons. One, for some reason, the intent of the parties can't be determined. an example of how this happens is, let's say a provision, sentence, coupling of words, right, gets dropped in word processing, right? And then 8 months later, when there's a dispute, cannot, for the life of you, recover that original language. The absence of that original language and of an agreed memory between the two sides of what that language was, right, might create on the face of that document an ambiguity as to that document, right? Doesn't mean that the parties don't know what was agreed to, right? But the face of the document is ambiguous. That means that the intent of the parties can't be determined from the plain language. There's an ambiguity there, right? Second situation. Let's say that that it just simply lacks a provision with regard to a certain important key measure, right? Let's say the price term or the payment date were left off, right? Or some other term that's maybe even more salient, right? Like a definition, right? That would otherwise be regarded as important for clarity, right? It's left out, right? That might create an ambiguity. Third, if you use a word or a phrase or use such words and phrases in a context that they are subject to more than one interpretation, right? And fourth, when there's any other type of uncertainty, right? So uncertainty is acceptable to more than one interpretation, a lack of a provision, or the intent of the parties can't be determined, right? If this ambiguity exists, then we have a deviation from the plain meaning rule, right? So we began with the objective theory of contracts, which says that the court will look to the evidence, right? The objective evidence rather than the party's subjective feelings and interpretations and visions of what they thought happened, right? The first rule, the objective theory, was that they're going to look at hard evidence. This rule, right, this sort of connects to that plain meaning rule, says that the words are going to be given their plain meaning and interpreted as such unless there is ambiguity. Then the ambiguity rule says, gives you the examples of when ambiguity exists. And if ambiguity exists, this brings us to the next rule, right? And that is that extrinsic evidence or something outside of the written contract, right, may be brought in to prove what the intent of the parties was. So remember, this is not, objective theory of contracts land, right? Because we're trying to figure out, again, if we're trying to figure out intent, we're trying to figure out if there was agreement or what was the agreement, right? So they can interpret the ambiguity against the party that drafted the contract. So if I left out some phrases that would have clarified what the heck we meant, right? And then I had you sign the contract, the court looks at that, they're going to say, well, you drafted it, Professor Keene, so we're going to assume that this was intended to be drafted the other way in favor of your client's interpretation or something similar to your client's interpretation, right? But in addition, or to arrive at this, a court may consider extrinsic evidence that was not contained. This is words or documents or reports of things that happened that aren't contained in the actual contract. Because if this was not a case of ambiguity, it would be only the words that are within the four corners of that document that would be relevant. So this extrinsic evidence rule may include testimony of the parties, additional agreements, additional evidences of communications, even in cases where there was a complete agreement, so emails and other things, or any other information that's relevant as determined by the courts in determining the parties' intent. And to illustrate this, I'd like you to take a look at the Wagner versus Columbia Pictures Industries case. That is case 10.3 in your book, but it's also 52 Cal Reporter, 3rd edition, 898 from 2007. 52 Cal Reporter, 3rd edition, 898 from 2007. And to close this out, I'll go over several of the rules that courts use, right? Rules of interpretation that you need to be aware of. For example, one, courts will try to give a legal meaning to all provisions, right? If it's possible to do so, right? Contracts will be interpreted as a whole, right? Specific clauses are subordinated to the reading of the whole agreement, right? And the general intent of the agreement. All writings that are part of the same transaction are going to be interpreted together, even if they're in different signed agreements, right? Terms that were subject of separate negotiation, meaning if I negotiated the definition of this term so that we can understand this agreement, those are given more weight than those that are generalized, right? So you should take a look at those. They include things like words should be given their ordinary commonly accepted meaning, unless defined otherwise. That's the parentheticals I spoke about earlier in this segment. Evidence of trade dealing, trade usage, prior dealing, and course of performance may be admitted to clarify an ambiguously worded contract. So that's fairly important. So there's 8 of them that kind of walk through these rules of interpretation. These are rules, right? If you're looking for generally applicable principles, there's 8 of them right there, right? That can be used with what we've learned in this segment. Again, look at Wagner versus Columbia Pictures Industries Incorporated, and I will join you in the next chapter, because this brings us to the end of Nature and Classification. Next, we will move on to Chapter 11, which is Agreement. See you then. Take care.